Thank you for the invitation to speak today. I'm a former DOJ civil servant myself, and I now lead Protect Democracy's Civil Service Protection Team. I'm going to start broad, and then I'm going to narrow in on what we are hearing from employees at the department and what they can do. I want to start by emphasizing that Congress has a constitutional interest in regulating the civil service that I think is getting lost in the noise. Over the past 2 weeks, President Trump and Acting Attorney General McHenry have demonstrated their belief that Article 2 authorizes them to ignore the laws governing the civil service. For example, President Trump's executive order on Schedule F, now known as Schedule Policy Career, we call it Schedule PC. The order asserts that, quote, Article 2 of the United States Constitution vests the president with the sole and exclusive authority over the executive branch, end quote, including the federal workforce. In other words, Congress has no authority here. Get out. Now, it's always worth reminding ourselves that this is wrong, and it's wrong for at least 3 reasons. First, Congress has long exercised the power to establish, define, and regulate the civil service system to protect the general welfare. That history and tradition balances this legislative authority with the president's primary executive control over political appointees, a very, very small cadre within the executive branch. Second, congressionally enacted laws are dead letters unless faithfully adhered to and executed by the president and the executive branch. In other words, in order for Congress to effectuate its legislative interests as defined in the Constitution, it must have regulatory power over federal employees. Such regulatory power is necessary and proper for carrying into execution Congress's other constitutional powers. Third, Article 2 of the Constitution vests in the president the duty to take care that the laws are faithfully executed. And the law, the Civil Service Reform Act, the First Amendment, and the Fifth Amendment, among others, require that certain procedures are followed and certain rights are respected when the executive branch takes personnel actions or otherwise interferes in the civil service. So, what happens when the executive branch refuses to recognize Congress's prerogative to regulate the civil service? We get corruption, we get cruelty, and we get the consolidation of power. Executive branch purges under cover of, quote, civil service reform are ripped straight from the authoritarian playbook. They are used to steal power, wealth, and dignity from the people and to consolidate it in the hands of the leader and his apparatchiks. They also accelerate the transformation of the federal government from one governed by rules and laws to one governed by the whims of power. For the political theory buffs amongst you, this is what academics call the transition from the normative state to a prerogative state. For current and former DOJ employees, and I'm among the formers, for those who have devoted their careers to upholding the rule of law, who have spent decades ensuring that the government dot every I and cross every T on weekends and holidays, this is a particularly heartbreaking transformation. It is also having material impacts on the daily lives of people at the department. Some of those impacts are obvious, examples like the fork in the road memo, the apparently lawless firings of the career attorneys on Jack Smith's team, and all of the gutting examples that Ranking Member Raskin set forth. Other impacts are more subtle. These include, for example, attempts to remove employees' ability to call out unlawful acts, as we see in the Schedule PC executive order, in which it appears inconsistent with federal whistleblowing laws. Attempts to exploit employees' sense of vulnerability so that they will turn on each other, for example, by telling them there will be adverse consequences for failing to report on colleagues. The collective impact of these actions are harrowing. DOJ employees with whom we have spoken describe a climate of fear that has changed the nature of the workplace. People are afraid to talk to their colleagues. They fear being ratted out by someone who feels pressure to demonstrate their loyalty in the new administration. Social trust is one of our nation's most precious assets. It's critical to an efficient workplace. And when it is lost, it is extremely difficult to regain. I think our federal employee friends, and especially our DOJ friends, I think of them as sitting inside a very dangerous triangle. Its 3 points include an authoritarian style, at times lawless government action. Second one is the threat of reporting by peers on the inside. And the third point in this triangle is the threat of doxing and even violence, all too familiar to the January 6 prosecutors by administration allies on the outside. This threat triangle creates a special bind for DOJ attorneys. Because while all federal employees have the rights and obligations to refuse an illegal order, this obligation carries additional weight for DOJ attorneys and puts into relief that the relevant question is not whether an attorney stays in this environment, but whether they can stay and continue to uphold their ethical obligations. DOJ rules and regulations set high standards for ethical behavior, in many places protecting against even the appearance of conflict or bias. DOJ attorneys are also constrained by the professional conduct rules of their state bars and any courts in which they appear. Thus, while they may face immediate immediate and legally unsound employment consequences for questioning colleagues or opposing the chain of command, they may also face consequences for failing to do so. And the consequences for the latter may be longer lasting for their careers. These various applicable standards are nuanced, and I won't go into the details here. I've spoken long enough, but I will share that Protect Democracy's new report, Supporting and Defending the Constitution, a DOJ Attorney's Guide to Upholding Ethical Obligations and the Rule of Law, which you can find on our website, protectdemocracy.org, details these standards in a comprehensive yet user-friendly way. We even have flowcharts. A few other final resources that I will direct folks to. The Partnership for Public Service has a new set of webinars for civil servants to help them know their rights and recourses. Protect Democracy's Dear Civil Servant newsletter series, which runs as part of our If You Can Keep It newsletter, lists resources as they come online each week. And Civil Service Strong, which Rob mentioned, is a website that our friends at Democracy Forward have set up that pulls together a collection of resources for civil servants. One of those resources that it points to is a user-friendly write-up of how to appeal an employment action of the MSPB, which includes reminders of the 30-day deadline for filing an appeal. I want to say that again, a 30-day deadline for filing an appeal at the MSPB. With that, I want to thank each of you for holding this important briefing and for working to protect the Department of Justice and with it, our nation. Thank you.